Time to go to work. Good afternoon. I call to order this special board meeting for the Monroe Public Schools Board of Education. Today is Monday, July 20th, 2026, and the time is 6:30 p.m. Jamie, can we have roll call, please?
Yes, Mr. Heck.
Here.
Mr. Dinkins.
Here.
Ms. Myers.
Here.
Mrs. Drosky.
Here.
Mr. Vincent.
Here.
Mrs. Williams.
Here.
Can we please stand for the pledge? I don't see the disclosure, but us. Just for everybody is aware that this meeting is being live streamed. There's usually a couple of cameras in place, one focused on the Board of Education and one that will be focused on any speaker that comes up to the podium, just so you're aware. Public commentary for agenda items only. I know Brian's not here tonight, but we have none. Okay, thank you, Jamie. Next, we have board discussion items, and I'll turn it over to Superintendent Shaw for the MHSAA discussion.
Okay, so last month, the Board of Education asked us to move the MHSAA from the approval into a work session, so it's here tonight. So I'd like to turn that over to our board to ask questions. We do have our attorney, Jeremy Chisholm, with us tonight to assist us through any kind of legal questions that may be needed. So I'd like to turn it back to you, and so we can start answering questions.
Okay. Well, I'll open it up for questions. Carrie, do you want to start with any questions?
I don't have any.
Darla?
You want to go down there?
Oh, no?
Okay.
Well, I kind of keep a little, Brian's not here, but I'll keep a little 3-minute timing going.
Okay. So, last time we had a discussion, we held, the vote on this because of everything that's happening and going on. Reminder that Andy had spoken to them, and they said technically you have till the end of September. The only thing that would not be applicable for 1 month would be an insurance thing. So what I did is I went in and pulled the entire handbook from the Athletic Association, and then I pulled out what I think to be relevant information that I think to help us understand what is the Athletic Association, what do they do, and the impact of accepting what they have put forth. So if you think that's beneficial, I can run through some of this information and catch us up. Anybody think that's relevant to the conversation and would like to know more about it, we can do that. Anybody answering?
I like to listen. No. Do a couple of items and we can kind of
Yeah.
circle back around.
Yeah, okay. Michigan High School Athletic Association, it's a private voluntary association for public, private, and parochial schools who choose to participate in the organization. I'm reading their language. Back in 1977 and 1986, the Attorney General has determined that it is a private, not a public entity, which makes a difference because it's basically a business that provides a service. The legislative body is a representative council, and the councils develop rules and regulations that tend to promote fairness and competition for the students and balance it with other educational programs and activities. The primary thing that they talk about is postseason tournaments is what they focus on. And the other thing is that they sponsor tournaments and they pay for it and they cover the cost of those. It's not necessary to join the program in order to conduct a program of competitive athletics. They recognize that. Member schools, they're not prohibited from engaging in competition with other schools that are not part of the athletic association. So you don't have to do that. It goes on, tell me, one thing it said under their leadership and services, it's a voluntary association of schools. Member schools may engage in competition against schools which are not members. Again, they keep bringing that up. and that there's nothing real or imagined that compels a school to belong to them except the quality of service that they attempt to provide to the members. And I think that's a very important thing, what their purpose is and what they're trying to do. They do talk about the accidental medical and concussion care insurance plans. And if I'm correct on my assumption, that's what they're talking about for that 1 month that may not be available. My understanding is, I don't think they've used that based on what I kind of read in here. I don't think it's something that is used very frequently, if at all. They have a Women in Sports Leadership Conference with mini grants and annual awards. They do talk about, what they plan to do here. It's interesting because there are roles in here, I found out a lot. For the statement of relationship, it talks about the superintendent's responsibility for athletics. It talks about the principal. It talks about the athletic director. It talks about the coaches. And what's interesting, and it goes into your officials and stuff. What's interesting is it says if you join this, not only do you have to accept components of it that we were up for a discussion, but all of these things have to be included as well. And these are things your school should be doing in order to be part of it. So I have that list we can go through if we want. They do have a gender and ethnicity portion of it. They also have a 10 beliefs that they hold, and I found that interesting. A lot of people say you can't, I've heard this, you need to be in this membership for college and stuff, and that's not what they're about. They are about high school program for athletics strictly, that it's fair and whatnot. And they specifically say that interstate competition and interscholastic athletics is unnecessary in most situations. Regional and national events are harmful to the purpose of the interscholastic athletics in Michigan. So I thought that was useful. So there's more in here that if we want to open the discussion on this, I think that we have the time. We have until technically the end of September. We have policies we need to go through that are related to this. So we can always, push this down if we want to.
Just remind everybody, this is discussion only tonight. There's going to be no actions taken. The way I believe that there's something there that says if you have to be a member to be in the postseason tournaments. Is that correct?
So what they say about the athletic association is particularly for the postseason stuff.
Yeah.
So it's not for your seasonal stuff. It's because they offer the competitions at a I don't know what level you call it. They call it high school academic and high school level. They don't call it anything outside of that. They just want to provide a platform for what they believe is an athletic program for kids in schools. And so I learned a lot.
But they're a private entity. Are they a 501c3? Is that correct?
They are. They're registered as a Michigan nonprofit corporation. They have most likely obtained 501c3 status, but I have to go to the IRS for a report on that. So that's the federal level. But they're a Michigan nonprofit corporation. I have their registration saved here. They've been around since 1972.
Okay.
And in answer to the question about participation in postseason athletics, they're the biggest and oldest, so that's why most schools choose to participate in them. There are, for example, different club programs, AAC, UAC, all these others, and there's a couple of private parochial circuits around the state as well. But simply by virtue of age and size, most
So for public schools,
Most
they're
public
probably the
there's-
only option. for
currently
postseason.
existing, there's not an alternative body for public schools other than sending kids to like the club things, or if
Yeah.
you could ask to join one of the parochial circuits or something. There's not, it's not like American League and National League or something like that, where you've got competing organizations that you could join.
Can I make a comment back? What I found interesting when I read this was that they specifically say, I know it was a 149-page handbook, so I didn't go through it all. I just picked out what I thought was relevant. And it said in there, make sure every year you read what we change and make sure that you agree with it. And I thought that was, they seemed very straightforward in saying, look, this is the way we're going to do it. And we understand it may not be something that you want to choose to do, because if you look at the requirements for the superintendent, athletic directors, there's a lot of stuff. There's a lot of stuff.
What's the enforcement arm of this if you do disagree with them?
You just don't join them. And that's what they say. Make sure you read it. If there's things that you can't commit to as a school district, they're very much, correct me if I'm wrong, Jeremy, school district board of education. They believe that those are the ones that are decision makers. And they say, if you don't agree with us, then don't choose it. Am I getting that kind of right? You can say
I
no.
think there is a line to that effect in the handbook.
Yeah.
Is it okay if I speak to Gary's question on that in terms of enforcement? So because it's a private, it's a nonprofit corporation as opposed to a body of government, they don't have a police authority. What the consequence is if you do something, if you sign on and you say, we're not going to participate, then it's my understanding, some of this is a little bit opaque. I don't have any personal interaction with it. But the executive committee meets regularly and makes decisions on behalf of the body about, are they going to exclude a team, a school, a player for some violation of the rules or the contract? Because essentially, this isn't 100% the best way to put it, but it's a pretty close paraphrase. It's a contractual organization. Like, it exists as a nonprofit, but to participate in it, you sign a contract that says we're going to join and we're going to follow your rules, essentially. Most of the times that lawyers get called to get involved with MHSAA stuff, it's eligibility. When one, like Catholic Central wants to borrow a kid from somewhere or something like that. That's usually what happens, or somebody moves and then they say, you haven't waited out our waiting period before you can start playing sports at the next team or whatever. That's most of the stuff. And the penalties are normally, so I'll give you an illustration that's been in the news, so it's not talking about anybody's business. Celine last year self-reported that they had a residency issue with one of their football players. It was a big deal for them because they had a huge season and they were leading their division. And when they self-reported, MHSAA said, we're going to take away 2 of your wins, and it completely blew up their postseason. But that's the way it was, and Celine said, we'll live by it. We self-reported. We admit that we did it wrong, and that's the enforcement mechanism, is usually they say, you can't play this game, or we're going to alter your record or something like that. But they don't have a police authority. They can't take money away from you or something like that.
I guess the reason I am talking along those lines, I mean, the elephant in the room is that we're going to change possibly change some policies, okay? We got the Supreme Court ruling. We know what they said. We know what the executive order is. And the MHSAA says, well, we're not going along with that. So now what? Can they hurt us if we say, okay, we're going to follow the law according to the Supreme Court, what they said? And so can MHSAA hurt us because we're following the law?
So if you choose to participate in MHSAA, which again, that's just the default for running postseasons, and then you did any kind of action, whatever it is, whether it was a policy or specific players said they didn't want to participate, or a team said, whatever it was, then that's where it goes into that executive committee of the MHSAA, where they decide, are we going to enforce it? Are we going to not enforce it? What are we going to do? Are we going to penalize somebody? Are we not going to penalize somebody? There's situations where there have been non-compliance by a team that didn't result in anything happening. They didn't want to pick the fight, essentially. MHSAA didn't want to pick the fight, and so they just let it go. There's others where they do say, well, like Celine, we're going to take 2 of your wins away, something like that. Another one that I dealt with recently, I won't say the district because it was fairly recent and not public, but one of the other rules they have is student athletes are only allowed to participate in 1 all-star game per year, whatever, and that's a little bit ambiguous what an all-star game, what counts for that. And so I represented a district that had a young lady who's already been recruited to do a D1 school. She's a very talented athlete, and she played in an all-star game, and then she went and played in another game that she thought maybe wasn't an all-star game, but MHSAA said it was, so they wouldn't let her run track because of her fall sport. Like, she competed in these 2 games for her fall sport. They wouldn't let her run track. So To me, the operation of how they make decisions is not entirely transparent, but it's done by the executive committee, and it's not uniform, like you do one thing and it's an automatic, you're done playing sports or something. Like they convene and they talk about it and then they make a decision.
Is there an appeal process if they do?
There
issue?
is, that's how I got involved in that, so.
When you look at this, there's all kinds of rules and regulations in here for everybody to follow, but I did pull those specific ones, Gary, and I wanted to read what they said about it. They have on page 126 of their handbook, it talks about eligibility of transgender student athletes, and it's the way they word it. And it says, when questions arise, that it's case-by-case basis, as Jeremy was saying, after being provided at least 30 days prior to the opt-out due date for what the tournament by the administration of the school for which the student seeks to participate, documentation to answer the question. So they got a process. And it sounds like it's a very, very straightforward process. But they go on to say that one of the requirements, it says, they will require a petitioner, if 18, or a parent or guardian, if not, to sign a waiver that says, I give my consent for the student to engage for the disclosure to the Athletic Association, information protected by FERPA, HIPAA, and Michigan law. And it goes on to say that. So in order to do that, they're saying, hey, you got to give us all this medical and all these kind of informations for them to make a decision. So obviously they're looking at it from a different perspective. The other thing that in the back section here, when it talks about that again, I'm sorry, it's gender and ethnicity. And what it says is, they believe that gender and ethnicity equity is more than being in compliance with the law. It's a spirit. It's a commitment to do what's right and fair for all athletes, and it goes on from there. But the bottom paragraph says, while the association does not have the authority to promote specific interpretations or to rule on compliance issues regarding federal and state law, which is what you're referring to, it does believe that all concerned should take steps to promote the spirit and intent of gender and ethnicity and equity. Now, Jeremy, that falls to you. When I hear that, it sounds like, look, we're not going to go against the law. We're going to keep our policies the way it is, but when push comes to shove, tell me, Jeremy.
I'll do my best. And again, I don't have any business with them other than representing K-12 schools when they get dinged by MHS. So I've only ever experienced them from an adversarial perspective. I've never worked for them. So you understand my perspective on this. I would imagine that out of basic desire to stay in operation and not be busted up by the state and or feds, that they would try to act within the scope of the law most of the time. They're registered as non-profit corporation. They're responsible for hundreds of thousands of student athletes across the state to the extent that they're participating. And so I would hope that they have a disposition towards complying with the law. They have publicly recently taken a posture that Michigan law requires them to maintain this waiver policy. I disagree with their legal analysis, but that is their perspective. So I don't want to, I promised Stacy I wouldn't ramble on lawyer things for too long. I took 30 seconds on basic response about the Supreme Court and what it means or doesn't mean for MHSAA. So I know we were all hoping that we'd get the Supreme Court decision and kind of like solve all these answers and provide a firm guideline on everything. And it did for 27 states, but Michigan's not one of those 27. So let me explain what I mean. 27 states have state-level laws that say no boys are allowed to participate in girls' sports, and that's what they say. It doesn't talk about transgender. It says no biological males in girls' sports. 27 states have those laws. Two of those laws, Idaho and West Virginia, were challenged by individuals who are biologically male and wanted to play on girls' teams in each of those states. One at the K-12 level, one at the college level. And so the Supreme Court heard that. The decision of the Supreme Court was that those state laws are okay. They don't violate Title IX and they don't violate the Constitution. That's what the Supreme Court ruled, is that those state laws in those 27 states, it's not a violation of either Title IX or the Constitution to say no biological males in girls' sports. And that's it. That's what the Supreme Court's ruling was. Michigan doesn't have one of those laws. Michigan, some people say, MHSAA seems to believe, has the opposite. I don't think actually Michigan law has been explained this way or litigated this way. Excuse me. Michigan has the Elliott Larson Civil Rights Act. For years, it said age, weight, national origin, et cetera, et cetera. It's been expanded over time. And most recently, 2 years ago, summer 2024, that was amended to include the phrase gender identity onto that list of protected attributes. That addition and what that means for a school and for school sports has not been litigated in Michigan. So MHSAA is taking, and I just pulled up their press release they put out after the Supreme Court case where they said we're going to keep doing things the same way. And they also said, and this was what had stuck in my mind, that our method of handling this through the waiver system is required by the Elliott Larson Civil Rights Act, according to the state spokesperson for MHSAA. I disagree with that legal assessment, but that's their position. They think that they're complying with Michigan law by doing that. And while I know it might not make intuitive sense right away to say, well, isn't that inconsistent with the Supreme Court's case? It's not actually inconsistent with the Supreme Court ruling because the Supreme Court was addressing those 27 laws in 27 different states that say no boys and girls sports. They didn't go beyond that. They didn't go into what if you have a different law, what if you don't have that, anything like that. And so that's their position is they think they have to do this for Elliott Larson compliance. If they hired me, I would tell them they don't have to, but they didn't hire me, so I haven't told them that. So, yeah.
Stacy, any questions, comments?
Can you go over the part about the gender and ethnicity again, please?
So there was two portions in here. And I will tell you, Jeremy, I did spend significant time and I could not find anywhere where it talks about the waiver. All it talked about was them going in and meeting with their executive committee, making a decision. Because I wanted to see like what the waiver thing was and I could not find that.
The executive committee is kind of a black box to me. Like
Yeah.
it goes in and then they make a decision, and I don't know what goes on inside of there.
Yeah, I couldn't find that out either, just so you know. So, there was two sections in here, and the one is eligibility of transgender student athletes. And we can make a copy of this, so everybody's got copies of any of this you want. And it says that they don't prohibit girls from participating in boys' sports, but it gets down to the end and it says, when questions arrive involving a male to female student athlete, the Athletic Association executive director will determine eligibility for their tournaments on a case-by-case basis after being provided at least 30 days prior to the opt-out due date for that tournament by the administration of the school for which the student seeks to participate, documentation that answers the following questions. There's two questions. When I read that, it sounds like you can pull out of the tournament if there's an opt-out, that would be the tournament, Jeremy. Am I interpreting that
think
right?
that's right.
So you'd have an opportunity to get out of the tournament. So this has to be done before that. So it sounds like that some people have information. The two questions are, what gender is recorded on the school documents for the student? A, high school registration. B, high school transcript. C, health immunization records. And D, pre-participation physical examination form. Then, number two, what does this student's other records indicate? Medical, psychological, that's A, B. C, if applicable, would be like a driver's license, voter registration, selective service, or Social Security. Remember, there's a category for over 18 and under 18 in here. And then the question number three is, has the student commenced, ... A, hormone therapy, if so when, and B, gender affirming surgery, if so when. And what's interesting is, like it says, it goes on to say that basically they have to give all their personal FERPA, HIPAA, everything rights up in making that determination. And then the second part of it was back in, on page, well, it's at the beginning, so it's on page 10. And in there, that's the one where it talks about the code for the principal, the superintendent, the athletic director, and everybody. And at the very end of it, it says, the Michigan High School Athletic Association believes that gender and ethnicity equity is more than being compliance with the law. It's a spirit. It is a personal ethic. It is a commitment to do what's right and fair for all athletes, officials, coaches, and athletic administrators. And I think that's where our questions come in, and that if I'm interpreting, what this says, in an atmosphere where no person experiences discrimination based on gender or ethnicity. If it is the positions of they're really clear about what they believe, just so you know, if you read this, like they're an open book. That the member schools monitor the athletic programs to ensure that athletic offerings are equitable and meet the interests and abilities of student athletes. While the association does not have the authority to promote specific interpretations or to rule on compliance issues regarding federal and state laws, it does believe that all concerned should take steps to promote the spirit intent of gender and ethnicity equity. So, like I said, I couldn't find like all the waiver stuff, and I couldn't do that. But they do have a lot of clear rules in here, and they flat out say it. If you don't want to abide by this, like there's a thing that the superintendent. Sorry, Andy, I'm going to point you out because it's not you; it's just your role. Like they have to advise the Board of Education. They have to use all mean. So there's a whole bunch of stuff that the superintendent himself has to do. And so to me, they're saying, look, read all this. It's 150 pages. You either agree or you don't, and we can accept it if you don't. Did that make it clear?
Yeah, I guess I'm just questioning how it's fair.
Yeah. And that's why I made the suggestion is we
Woman
have time.
athlete, Female athlete, how's that fair?
So we do have time.
And I wonder how they make up their committee?
Will
So the
That
executive,
was my
not
next
find
question.
out
The
a whole bunch
executive-
of that.
Who
The
are
executive-
these people?
the executive committee is made up of athletic directors and or administrators from.
Oh, there's a whole bunch of them. They give you the names. I didn't print them off, but they do, I'm sorry.
There's regional representation.
But see, the legislative body, I think, is who you don't get the names for. Was the legislative body
Like
listed?
the executive committee or?
There's an executive committee and a legislative body, and the legislative body is the representative council.
Right, which is still gonna be made up of.
Yeah.
Of athletic directors and so.
From schools I never even heard of.
Yep.
Is there any school, anybody, a representative from a school in Monroe County?
Not that I saw. There was a section in the handbook where it said basically our area.
Yeah.
And I don't know if it had a to be determined or it had something, but there were blanks for certain areas of
Yes.
representation that weren't there. So I'm not versed in it. That was just what I saw.
So members of the representative council for our area would be athletic director from Brighton. And they go by class sizes too. So that would be our person. Statewide at-large person, Mount Morrison, Fenton, so you got principals, so it's made up of administrators. Make that up, so ours would be, and then we do have appointed members, the athletic director from John Glenn, Weston John Glenn, and Plymouth Ken
Oh,
superintendent.
so maybe I did recognize them.
Andy, between yourself or athletic director, do you go over these rules with your coaches?
So the athletic director, every year we all get get this handbook, and so the new handbooks haven't been released to us yet, but they will be, well, potentially. And so they go over making sure they understand the highlights. Generally at the front of their document will be all the changes. And so the athletic director will go over the major items. The coaches also take part in a program through the MHSA too. That's one of the requirements of head coaches. So, and the biggest areas that we always pay extremely close attention to is transferability.
Yeah.
It's all about
Yeah.
transfer is probably the number one area that we have.
Transfer meaning,
So
Student transferring in, student transferring out, eligibility.
academic eligibility would probably be a big thing.
Those are the big ones there. And then the other part is if for example, if a coach gets kicked out of a game or if an athlete gets kicked out of a game, the officials report it, and then the athletic director's on the phone the next day with MHSA. So that way the coach or the student understands, the number of games that they're out after that. But that's probably the most area that they spend time on.
Mary, do you have any questions?
Just a few questions. So just curious about what other districts in our area have opted in versus opting out of MHSAA. I'm assuming that other districts also had this on their recent board meetings for discussion and voting. So I'm curious if anybody else has also not voted to be involved in MHSAA, and then also connecting with those board members to discuss like their reasoning behind that decision. Thinking about district, regional, state competitions, if we were to not be involved in MHSAA, how would we go about providing comparable programming? Because historically, we've been offering our athletes opportunities to compete in those levels of competition. How would we as a district be able to provide those types of competitions to those students if we're not part of MHSAA? Would we have problems scheduling all of our athletics if we're not a part of MHSAA? So especially considering if we do have to come up with some sort of comparable programming for districts, regionals, and state competitions, who would be responsible for that scheduling? I'm assuming athletic director, but when it comes to getting other teams involved in those comparable programs that are not through MHSAA, like what does that look like? And I would assume have to start scheduling those now, especially for fall sports. And then also, would we have problems getting officials and refs for games, considering that MHSAA, has registers for those folks?
So I'll answer a couple of those questions there. I did send a text off to the county soup, so I'll have that answer as we go on. So as Darla's already sharing, when it comes to the regular season, nothing would change. You're competing, the schedules are already set for the fall. Everything is a go. When it comes to then the postseason, that's where it all shifts, is we would not be allowed to participate in any postseason. So your district, your regionals, any competition there. So at the end of that 9th game in football or when cross country finished or that, they're done. And so there's no state level competition. And for the vast majority of kids, they know they're not going off to college athletics. It's more that they're going to go compete at the state level, and they're going to, for some individuals, have a state championship, and that's what they're pushing towards. Or others, you look at football, they made the playoffs, and so that is that idea of getting to Ford Field, and so on and so forth. And so that's what is a driving force for coaches and athletes, is about that postseason play to be able to go for that. But if we're not part of the MHSAA, that's what's gone, and there's no other options
Well,
for us to go take part in.
but I think there is. Isn't AAU and some of those other organizations, don't they offer a platform as well? Because I think they're like a junior Olympics. I did junior Olympics through AAU.
But I.
So it
to
provides
speak
a level
outwardly
of
on that, I can't go, yes, for certainty. You're still not that state level competition. So for example, like right now, if a student is a cross country runner, you can't go run cross country AAU. You can go play softball if you're a girl cross country runner and you're a softball player. You can go play softball all fall because it's not in season per the MHSAA.
But AAU does do running, or they used to.
Right, but we're,
It's postseason. It's
Yeah, it's a postseason.
typically after, if I can add it, because
Yes.
I'm familiar with it, after the state meet at MIS, some of the higher qualifying ones will go run at the regional AAU, which is usually in Wisconsin somewhere.
Yeah.
So, and then they have a national, which kind of varies, it gets moved around the country.
Whereas this athletic association is only state. They made a
Yeah,
statement
yeah.
in here that they don't say.
And I don't think AAU has anything like a football tournament that I'm aware of. They
I-
might have baseball. Yeah.
I don't know
It's-
what
and they
else
wouldn't-
there
It's
is.
limited number of sports.
And AAU really stays away during the end season because they know that high school athletes are not going to be able to participate in season with the same sport, so they're not going to see that happen.
And it's usually after the postseason even, so.
And then would AAU be eligible for the $100,000 investment that we did for pay to play for our student athletes? Or would that be additional funding that families have to come up with for their students to participate in AAU?
I think those are
Usually
questions we,
that's a cost.
I
So,
think they're
like-
questions we'd have to look at for sure.
So that's another consideration, right? So MHSAA right now, we've made this considerable investment in our student athletes for pay to play in our district. But then if we're saying, well, pursue these other alternatives like AAU and things to get additional play opportunities, that feels like almost going back on what we said about pay to play.
Does the league take any position on MHSAA? I mean, the league that we're in? They don't care if you're in or out?
Like for most schools, and you're a part of the MHS, the league doesn't really care because they're all about, they set the
Right.
games up.
Yeah.
They schedule it all and off you roll. But it's more about the idea of, MHSA just controls the postseason. The other part, I think, too, is understanding that MHSA, yes, they have a lot of rules, and it's to create that fairness of the sport. And from eligibility, from academics, to transfer, to recruiting, to you name it. That's why they have all of the stuff to try and keep the surfaces as fair as possible. To even when it comes to officials, that you have to follow their protocols and to be an official. And if a school, back to your Darla, what you were talking about, is if a school hires an official who is not a member and has not gone through the courses, then you're going to find some form of penalty potentially for that.
It said during regular play that those kind of things would not be a problem because it said non-member schools can participate during the regular season and get the same opportunity as everybody else. Because I'm telling you, they sound like they really, like their focus is to ensure there's a platform for students to be able to play and compete in sports. They're not really looking outside the state. They're not really looking out into college and those kind of things. I think what you brought up, Andy, is a very good point, and I think Mary's questions need to be looked at in a deeper level that I can't answer, obviously. But fairness. What is the definition of fairness? They say, hey, it's in the spirit of fairness, and that's an ambiguous statement, but when we look at fairness, there's a Supreme Court ruling on what they deem as fair. So I think that's where we sit is, maybe taking a deeper look into that. I like the fact that we have time. We don't have to jump with 2 feet into this.
Brian, you quiet?
I just got here.
I know.
It's wonderful in Pennsylvania,
Thank you. Hometown.
indeed. And the parliamentarian has not been here to enforce the rules, so we'll get back to the rules soon enough.
We've been
Jeremy,
doing pretty good.
you look like you guys are policing yourselves. I like it. Jeremy, is there any talk of any schools that you represent bringing litigation against the MHSAA?
Not at this time.
Not at this time, but it has a potential to do so.
It is definitely possible, sir.
I mean, I think that would be
Federal
one of
too,
the.
right?
Right, but what I'm saying is there, a school bringing litigation against the MHSAA saying they're not following federal law, they're being discriminatory in some capacity to what has been ruled. And I'm not saying that any,
Hundreds of school districts right now in the state of Michigan having the same discussion.
right, I'm curious,
What should we do?
yeah. But you haven't heard anybody say that, so.
I don't have any clients that currently have any pending litigation.
And when I wasn't here, what did you give as your, what did we ask you about the ruling, the federal ruling?
The Supreme Court ruling? Yes.
Yeah, and how it interacts with.
I
if
can
you-
recap that very
If you
briefly.
can, that would be
Yep,
great.
very briefly. It was not the comprehensive ruling that a lot of people were hoping for or anticipating, or that some people think that it was. It was actually a fairly narrow ruling. So the Supreme Court addressed 2 state laws. Those 2 state laws are representative of 27 states that have nearly identical laws on their books that essentially say no biological males can participate in girls' sports. That's what those laws say. So West Virginia's law and Idaho's law were challenged. One was brought by a high school student, one was brought by a college student. So both of those were brought to the Supreme Court, and there were many little challenges, sub-arguments, but the two big arguments were that those laws violate Title IX and that those laws violate constitutional protections. And the Supreme Court said no to both of those arguments. The Supreme Court said those 27 states that have those laws do not violate Title IX and do not violate the Constitution. So if your state wants to pass a law, and they explicitly said, we're not telling you what about girls and boys sports, not a part of the decision. We're not talking about bathrooms. Like, they have the first footnote in the case, in the decision, is a disclaimer of things they're not ruling on. That's what they wanted everybody to understand. But if you at the state level, write a law that says in Michigan, for example, or whatever state, no biological males are allowed to participate in girls' sports, you are allowed to have that law. That was the Supreme Court ruling. Michigan is not one of those 27 states. We have ELCRA. MHSAA believes they interpret the LCRA to be essentially the opposite, that they released a statement after the Supreme Court decision that said, we're not changing our course because we believe the LCRA requires us to do so. And what I shared with the board is that I disagree with that legal analysis. I don't believe ELCRA requires their format, but I'm not their lawyer. So that's the position they're taking.
I guess kind of expanding on that, being that the OCR is going, investigating us as well as Ann Arbor Skyline, is there a legal path for the OCR to go after the MHSAA, or is because they're a private entity they can't?
So OCR only has jurisdiction by law over recipients of federal aid. And so because MHSAA is not a recipient of
Okay.
federal aid, they might issue a press release, but they can't enforce anything with them.
I think one
Or
of
Hillsdale.
the conversation, the conversations that we're having, and including Mary's questions, including Brian's statements, was it's making the point of why we probably wouldn't be beneficial to jump on this right now. Because you're right, whoever said it, there's a lot of other boards, there's no doubt in my mind, that are having the exact same conversations, because we as a school boards have been put in that situation. By no fault of our own or anybody else's, it's the situation that we find ourselves in. And I would like to kind of see the waters and how things go, because we have time.
What I'm thinking about this is, are we almost putting the cart before the horse? We haven't changed, if we change our policy, then we can discuss, if it's different than what it is now, then we can discuss whether it's beneficial to be an MHSAA, or are they going to take, there's going to be repercussions against us.
You're right, because that will depend on what this board decides that our policies going forward are. And again, another reason why I think we need to look at all these factors before we do jump on this, because once you're out, and once you're in, you're in. So it's not like, hey, if we change our mind type of thing. I think you're right, we need to be 100% sure of the steps we're taking, and including the policies that we're going to be talking about in 2 minutes.
Common sense tells me, like I said, hundreds of schools are going through this. There's going to be a lot of schools that are going to say, nope, we're going to go along with Supreme Court ruling. There's going to be a lot of schools say, no, we're going to go along with the MHSAA. What a mess.
100%.
And I think somebody mentioned earlier about, could this end up in litigation? It's going to almost have to end up in litigation, because there's so many school entities involved in this. It's going to be a mess.
Well, I think what will likely happen, it feels like, is that the MHSA will be under some pressure at some point. If you have this, let's say it's 60-40, 50-50, whatever it is, there's going to be pressure on the MHSAA. If, let's say 35% of the schools say, no, thanks, we're not participating. And maybe some of those could be key schools. We don't know, there are obviously more key schools in athletics than there aren't. A school in the UP may be less key than someone else, right? That's how the facts are.
just
So
Marquette.
I think if the MHSAA were to lose some key athletic schools who say, no, thank you, that may put a lot of pressure back on them.
But there's going to be a lot of schools too, and Brian, I think you're right on track. They're going to say, okay, we'll join MHSAA, but we have our own rules. And these are our rules. And see how many, if they come back at these schools.
Yes.
Because there's gonna be a lot of schools that are gonna say, no, no boys and girls sports. And a lot's gonna say, yeah, there should be. Now what?
I think that's a mess. That's a mess of their own creation.
Exactly, you know, common sense tells me, okay, going along with the supremacy clause in the Constitution, here's the ruling. We need to adjust accordingly. I don't know, I see a mess coming for a lot of schools, not just us.
But we don't have to be the first.
Why not?
Well,
Oh, my.
Why am I?
Jeremy's itching for a court case.
I'm not. I'm not.
I never want my clients to be the test case.
Yeah.
so
Good point.
a couple of perspectives that may help too is remember, the MHSA has no authority over a school district's bylaws, policies, of any sort, okay?
Yep.
How we govern ourselves. And so however the policies go when we go into this work here in a little while, is how the policies go. It doesn't preclude this district from being a member of the MHSAA because it's all about what this district can control itself.
Right.
Okay?
Okay.
And so I think at the end of the day, you know, it's about what is decided for this district. And so if you're a member of this, and as Darla has pointed out, you know, if there's not to be, if Monroe Public Schools made the decision that boys and girls sports would not be permitted at Monroe Public Schools as an example, and we have a student athlete who wants to be, who's a boy wants to be a member of a girls sport, well, that doesn't happen. There's no repercussion by the MHSAA because they have, who has to put the request through? The district does. So
That's, it's solvable. It's when we get to the other side of it that
you
becomes.
have no control over the other side though.
Right.
Over the visiting schools, that's my point is you as a district, we have no control who comes and visits us.
But in
We have the
the,
authority over our own people, just not others.
but in the athletic association, like I said, they're straightforward. Read it all. If you don't agree with any part of it, just don't do it because this is the stand, this is what we're gonna do. And, you know, so I think they're straightforward in what they do.
I don't feel like there's, excuse me, I don't feel like there's any ambiguity in the MHSAA. They have been on this bandwagon since the beginning.
Right.
So I don't see them changing that. Back to Jeremy, I don't know what their black box formula is, but these meetings take place, are they public meetings? I'm assuming they're not.
No.
Right,
I've never seen one.
right.
Private
So,
entity.
It's a private voluntary association is what they're listed
Awesome.
in their paperwork.
Does this really boil down to
What's
just one
that
thing?
mean?
that tells me a lot about them.
What do we think is best for our kids? Isn't this what this boils down to?
Yeah.
What are the best kids, what is best for the kids of Monroe Public Schools? We got our Supreme Court ruling, now we gotta figure out what to do.
So would it be fair to say, based on what I'm hearing in this conversation, is just kind of, you know, this is a discussion, kind of settle where we're at now and just kind of hold and have the discussion on the policies? Is that what we're thinking?
That's our next.
Because we're not voting on this anyway,
Yeah.
and we don't have to put it up for a vote. I
Well,
mean,
see-
it's up to us when we put this up for a vote.
It seems like if we clarify our policy,
Yeah.
then we can discuss what to do going forward. Because we'll have our legal stand, this is what we believe, this is what we will do.
Okay.
Am I
And then
wrong?
if,
I think that's the proper process. Get our
Okay.
policies in place and then discuss further MHSAA and have, at that time, have the vote.
if anybody would like a copy of my blue, green, red notes, I will be more than happy to make you a copy, or Andy will maybe.
We'll just send out the MHSA handbook.
Okay. Leisure reading. Okay, any further discussion? Yeah, sure.
So, I understand that our deadline for decision is in September.
Yeah.
But with athletics formally starting in August, thinking about that timeline, yes, I understand that it's not until postseason that it would impact our athletes, right? But what I'm thinking about is if we opt out of MHSAA, yes, the season has started in August. We opt out in September. Now, whomever is responsible for scheduling our equivalent of district, our equivalent of regionals, our equivalent of state, that's my question,
That's
right?
MHSAA, that's not your athletic director. So what happens is when it comes to tournament play, the MHSAA takes control of that. And that's all done, like in the world of football, it's already been, they have a selection Sunday and it's all bracketed out. When it comes to cross country, well, you already know where you're going for your regionals. When it comes to each sport, it's already, the MHSAA runs the tournaments.
Right, but what I'm saying is if we opt out, I want to provide our athletes comparable programming to districts, regional, state,
There's
because
there's no comparable programs.
No,
Then
no, they're
I-
the biggest.
Right, well, that's my point. There's, if Monroe Public Schools opts out, our students will not participate after the last game of their season. They're done.
in any sport at all.
Any sport.
We're not even going to attempt to replicate
There's
that
no other-
type of anything.
I don't think we're making any decisions right now, and I just want us to be
no,
clear,
no.
this
Not
is a
making decisions.
discussion.
Please.
Yeah, it's a
What would our
discussion.
kids do?
Right,
I'm asking
Yep.
questions.
right.
When the season ends, there's no other opportunity. There's no other, like, okay, go compete. And with this group of schools that are not members of the MHSA, there's nothing of that sort that's been established because unless you're a brand new school, everyone's already members of the MHSAA. And some may not because they have a small school and they don't have the numbers for it. So another area would be like, for example, like wrestling, I know is a great example where lots of times they'll actually opt out of participating in the team tournament portion. They'll stay in individuals because they don't have a big enough team.
Right.
Okay. So so individually they get to that level, but our students would have no opportunity this year for postseason participation in any sport because there's no other avenues.
So we wouldn't even be able to replicate something of that magnitude if we were not electing into MHSAA.
Not immediately. Obviously, if enough teams decide to drop out of MHSAA, they would probably put something in progress, but to be honest, logistically, I doubt you could get it done this season.
Right.
It'd be
That's-
something for next season, maybe.
Right. That was why I brought up that timeline of athletics beginning in August this year. I was just wondering how it could ever be possible. And now I'm glad that we talked about this because that's where my mind jumped to was if we make this decision in September, I couldn't imagine anybody pulling this out of their hat.
I-
Okay.
I would tell you, even if we made the decision in the next week or so, it still doesn't matter because it takes a lot of time
Right.
and a lot of coordination to put together something like that, which is why HSAA rules, because it's all set. Nobody has to do anything. They just participate.
It would seem this next upcoming year is already taken care of. I mean, nothing's going to be litigated. This is all just a beginning for school districts talking about this. I don't think anything's going to happen until later on in the year when schools start coming out publicly saying, this is where we stand, this is where we stand.
The
Then
other,
it would start, it seemed like next year
Yeah.
would be the time when this would really come to the forefront.
yeah, and obviously the election, because so much is in play between the governor, Secretary of State.
That's true too.
I mean, if the government changes, then maybe things will happen quicker. If the government doesn't change, then things may not change.
So we might be premature even considering not joining MHSAA because so much is about to change politically and am I right or wrong?
Well, that's
Well,
why
that's-
give us at least a
you know,
couple of months,
yeah,
at minimum,
Yeah.
yeah.
I mean, you're looking at the MHSAA today.
Today,
We're saying today, what do they look like?
yeah,
Yeah.
We don't know what they're going to look like 3 months from now.
exactly.
Or next
That-
week.
That's my point, Brian.
Yeah.
This could change very quickly.
I mean, I think there's going to be some blowback
Yeah,
Oh, absolutely.
because I think the MHSAA is spinning against the wind, right? The Olympics said no. The NCAA said no. Pretty big institutions, and the MHSAA is still fighting out there for what they, if that's what they believe in, that's fine. I'm not impugning what their thought process is or what their beliefs are. But they are running against the grain pretty hard. And I just have a feeling that we might see some cracks develop
Yeah.
in the
It
MHSAA.
was a pretty quick statement they put out, I think, without a lot of
Thought?
long-term thought.
Yes.
Yeah, let's put it that way.
We're gonna bully people maybe a little bit,
Yeah.
right? Because we have this cornered, these people can't replicate anything, they know that.
Yeah,
But that doesn't mean tomorrow that's the
Right.
case.
right.
One thing that made me think of it when you said that, Gary, is, you know, I'm still think we should, you know, give this some time and see the playing field. But, when I read this and it's like, yes, if you sign this contract, you're gonna agree to do all this. And there's a lot. So it's not just one topic. But if you don't do it, I believe to Andy or Jeremy, one of them said, the repercussions are pretty much, we're not gonna let you play. So they don't really have a big stipulation if you don't abide by it. You know, the concern is to find our students in a situation that unbeknownst to them, can cause an issue. And I think those are things that we need to consider.
I think if you play the tape through, you know,
Yeah.
I don't have any numbers. Let's say 25% of the districts in the state say, no, we're not going to go along with this, no boys and girls sports. And here it is come November for the state playoffs. You can tell 25% of these schools, they can't be in the state playoffs. I don't think that's going to happen. Here's the blowback that Brian was talking about, right there. I don't know how this is going to end up, but
Mary, do you have something more to add?
I'm just curious what our student athletes and our student athletes' families think.
I was gonna say that too.
Great minds.
I think it's one of those situations where, I think it's one of those situations where we remind ourselves that we're elected officials. We're not appointed here. We're elected to represent those people that are in the community, and they sit us here to make tough decisions. And there are decisions that we are able to take to the community and get feedback on, but there's also decisions where the board has to take a stand. And this may be one of those situations where we're elected to make decisions, and we find ourselves that we may just need to do that.
What was the fee again? Isn't there a yearly fee?
They don't have a fee.
There's no fee.
And it's an annual sign-up, so
Yeah.
if we decide we're gonna stick with it because there's no alternative this year, and something comes up, next year we can opt out.
exactly.
Gary, to your point, there may already been schools in the last 10, 20 years that may have actually made a statement locally level that that boys are not in
We
girls'
just don't
sports.
know about
I don't know. It does, again, the MHSA has no control over that.
Right.
At the local
And they
level.
make it clear that they don't have
So-
anything to do with that.
Whether 25%, 1%, 100% of schools, it's irrelevant. Because you flip the opposite direction where the MHSAA has a stance of no boys in girls' sports, and another school though out there pushes and permits it, okay, they'll be in the same, they could be looked at in the same lens of, well, you got to prove and do everything there to prove that there is a boy and a girl sport, and then that to be deemed to be ineligible. Okay, so
That's the problem.
but
That's the problem.
My point is that if you flip it the opposite direction, you'll be in the same scenario that other schools may end up in down the road. I don't know. I'll get you guys the handbook.
If you want those page numbers, since I did the hard work for you,
And then we'll have,
And we thank you for that.
you're welcome.
then I'll do a little research on any schools that have opted out of the MHSA there this year. I know, and so far right now inside this county, there are none.
Okay, good discussion.
Is that what your info got? Is that what your info got?
Yeah,
Okay,
it is easier.
so we'll move on now to the non-discrimination board policy review.
If it'd be okay, since they're sitting here
Oh.
and Brian has made it,
Make it,
can we
okay.
just skip over number 3
I said that earlier.
for that action item, please?
we're going to skip down.
We're going
Go
to number 3.
And then come back to number 2.
Yeah.
Thank you.
So,
Got it.
Lieutenant Shaw, you want to
Yep.
give us the intro, and then we'll look. for-
So it is a recommendation of administration to move to approve the appointment of Holly Shear as an exempt administrator with Monroe Public Schools effective July 20th, 2026, and place on the appropriate salary step as contained in the exempt contract.
Can I get a motion regarding the approval appointment of Holly Shearer as exempt administrator with Monroe Public Schools?
I move to approve the appointment of Holly Scherer as the exempt administrator with Monroe Public Schools effective today, July 20th, 2026, and place on the appropriate salary step as contained in the exempt contract.
Do we have support?
Support.
Okay, discussion.
We want to go back to our,
Let's go to the 3-minute.
what we do.
Yes, what we do now that you're here. Okay.
That's why I drove all the way back to Pennsylvania, so I was worried about it.
You're up.
No, we're gonna start on the other side.
Okay.
Get the, I should get the benefit before I started, so.
Just asking questions.
Yep, yep.
So start now. Go ahead, Stacy.
What brings you back to Monroe?
So,
So you were Monroe
Yep.
previous Ann Arbor schools, and now you're wanting to come back.
Yeah, so,
Can we address the process real quick? And I'm going to bring it up just because we've never done this before. The board never interviews anybody. It's done by the administration. They bring the recommendation, and we kind of give a heads up and heads down. We usually ask our questions of the administration rather than employees. So I just want to make that known, like, we've never done this before, and just an FYI there.
I would agree that we had several members of staff on the panel, and they've done their due diligence in terms of interviewing, that we're here for basically to approve or not.
How many were
We
there?
can ask questions of
Andy,
Andy.
but I don't think we should be asking you.
Thank you, Terry. Yeah.
It's just not our job.
Okay,
all right, thank you.
thank you, Howard. Okay,
So I'll answer that question.
Thank
So,
you.
I believe the date was back in 2018. Holly interviewed for the HR position, and then after that had the opportunity, was recruited to Ann Arbor. This is home, born here, has lived here her whole life, and views that having that skill set that has been established and to be able to come home to end her career at Monroe, a place where she started her career and started out at, if I remember right, so I've got to ask her one question, everybody, okay, because I want to get it right. It was really as an administrative assistant, or was it more of even an aide?
I actually started as a co-op student, to be real.
There we go. So,
Right out of high school.
yep. So it's more just that opportunity to come back to Monroe and to give back with the skills that has been developed over the years.
Stacy, you're still on the clock. We have more questions for Andy.
I don't at this time, though.
Terry, you're up.
I don't have any questions. That was the one I had. Andy, welcome her back for me, would you?
Well, so if I could take 1 second, I think I want to share a couple things. We had roughly 18 applicants, interviewed 5, and brought 3 back for a second round. On the day of our second round interview, one person removed their name. And they removed their name because they didn't have their presentation fully put together in a professional way that they felt would be appropriate. So we had 2. And so when we look at what Holly provided us, was just, I think what was striking was, she goes, what I learned when I went to Ann Arbor was getting in and really understanding the data and being extremely accurate in the data. And that's from the staffing size of buildings and to having everybody certifications, to all of it. And so that was one of her big takeaways there. And so that, for myself, was very important to understand, was that attention to the detail mattered there. And so that's what the candidate pool looked like. First round was just normal questions. Second round, what we asked them to do was to present how they would take and the strategic plan and implement the strategic plan, HR's impact on the strategic plan, followed by a 90-day entry plan. Because we're walking into August, start of the school year, what that would then, how that shakes out. And so she put a presentation together on that for us, and an understanding from the surveys to the retention and what that'll look like. So she incorporated the strategic plan so she understands HR's position with the strategic plan. So.
When I was hired into Monroe Public Schools, I had the great fortune of asking Holly so many questions. So I'm very excited to see you back. That's all.
Am I on the clock or are you?
You're up.
You
Go ahead.
usually wait till the last if you want to go now.
No, I do have a question because, and so the answer can get to everybody.
Yes.
Given the OCR investigations into both Monroe and Ann Arbor Skyline, probably coming from Ann Arbor, is there any issue with conflict of interest or involved in this investigation?
Thank you. So I actually asked Holly that specific question, and she had no part in any investigation. The Title IX is handled by her superior, it's the assistant superintendent. She's aware to a degree, but that of what's going on, but it's a small degree because you remember that Ann Arbor has 16,000 kids, 35 or 38 buildings, and her job is very specific, and so she does not get into no linkage between the two worlds.
Yeah, that's my question.
Based on an earlier conversation, the contract language was one of the points that I had brought up, because the way the language is written, I did not see anybody else's contract, the previous ones for the administration. And so I wanted to verify the way the language is written in the contract is understood by the board, that it is a 2-year contract that would, Andy, go ahead, because I don't, thank you.
So how the contract is written, it is a 2-year contract right now. Current board, cabinet members and myself have a 3-year. And as of April 1st of each year, unless the superintendent makes a recommendation to you in regards to a cabinet member, that contract just would renew. And so at that, and so.
So it's only by your recommendation that
recommendation.
anything changes?
Or a cabinet member, correct. And so it's kind of like, Darla, you've talked to me before, or talked to the board before about, you have one employee.
Right.
Okay? And
I'm talking to him.
So if come next February, I'm making a recommendation, you pick any cabinet member, and I'm making a recommendation to you, then there's a process that's been established, and then that, to not renew that contract, then they'd be underneath 1-year contract left at that point. And so that was the only change compared to any other executive director position, is they are all 3 years at this time, and this would be a 2-year.
Thank you.
So I have a question about the job postings. The original job posting asked for teacher certification. I believe that was either obligated or preferred.
I think it's just preferred.
Okay,
Do we have the language of that?
but that's important to know what the job posting said.
Yeah.
That was, I think there was, I needed some clarification on the job posting. That thing was not up very long. How long was the job posting up?
We posted, I'm sorry, I gotta dig back there.
Okay.
I want to say that the posting was up 3 weeks.
Okay.
We just voted on that. When? We just voted on it like
Well, you guys actually.
Oh, we had a month off, I forgot. We
Well,
had a whole
early
vacation
June though,
month.
it's pretty, early June.
We had a whole vacation month, I
Yeah,
forgot.
early June is pretty clear that we needed,
Yep.
to bring on an HR director, so that's when we went through the.
Oh, so you posted it back in June.
Yes.
I'm just making sure I understand the certifications and why we have, if it was preferred, that's different, but if we ask for teaching, a teacher certification, I don't believe Holly has a teacher certification.
1 second.
Is that correct?
Thank you.
Is it correct that Holly doesn't have a teacher certification?
Correct.
Okay.
See fingers going. Someone's pulling it up. We got 1, 2, 3, 4 people. David's got it. Brian, could you read it out loud, please?
If I get it, see it.
So a valid teaching certificate with successful teaching experience is highly preferred.
Highly preferred.
Okay.
So that is different than preferred. Highly preferred
Yep.
is a different terminology. Also, I'd like to take a moment because I think somebody has miscommunicated my position on the HR director. I did not say ever that I wanted an HR director in as quick as possible. That was never said by me. The only thing that was said by me was that I would like the HR director position to be separated from the finance director. So if that is a rumor that's inaccurate, fine. I am clearing it up right at this moment. I want the right person there, not the person there the fastest. And that's where I stand on that. Did any of the other 5 applicants, did they have teacher certifications?
So, one.
The first 5, so only one had it out of the 5?
I'm sorry, 2. We had a prior superintendent, and yes, 2 out of the 5 had.
And the 2 out of the 5 that had it, did they also have the HR accreditations that Holly would have had? No?
No, neither one had any accreditations for HR.
That's it for me.
We want additional questions? Go around again. Anybody have any additional questions? Okay.
I don't have any.
No,
I don't have any.
Mary, you okay? Okay, in that case, then, Jamie, can we have roll call, please?
Yes, Mr. Jenkins,
Yes.
Ms. Myers,
Yes.
Mr. Sabatini,
No.
Mrs. Trosky,
Sorry.
Yes.
Mrs. Vincent,
Yes.
Mrs. Williams,
Yes.
Mr. Hunt.
Yes, and the motion carries. Welcome aboard.
Right.
Welcome aboard.
Word.
Welcome.
I know mine are, they blast us right here, very cold. You see me moving, that's why. Is it cold there too? They told me they turned it up. I don't think so.
Oh, okay.
Brian was.
Okay, all right, yeah.
Getting it signed right now.
Graduate with
He's getting it signed right now.
What time was you
Yeah,
short?
I guess he's getting signatures.
Wow. I don't think we've ever done that before.
Okay.
Brr.
This
I
is,
think we could use heat at this point.
oh, it feels good.
I know, it's my fault I didn't bring a coat. I understand that.
What do I need?
You cold?
This is 60 and 66.
cold.
No, I'm good. If anybody, give it to Tara.
You want the jacket?
Oh, go around.
You want the jacket?
I'll hold off right now. I don't want to take your coat. If I can't take it no more, I will take your coat.
Okay.
Aw. Thank you.
Welcome.
Start recovering.
I moved it to 71.
That is, that
You don't
is,
have your blanket?
I can move it to 70.
it's the cold air blast.
It is, I know.
Thank you, Gary.
Welcome.
So next on our agenda is the non-discriminating board policy review.
Yes.
And I'll turn over to Superintendent Shaw.
Excellent. Thank you very much. So in your packet, we have policies 1422, 3122, and 4122. These 3 policies are replacement policies created by Neola And they're taking out their 1422.02, 3122.02, 4122.02, 1662, and so forth. They're combining them together, okay? Is what they've done. And so what I'd like to do is go through, and you can see we've already kind of gone through and highlighted areas there. We really only need to go through 1422 because the other two would be exactly the same. And so if we could just kind of walk through, and you've got that in front of you and talk over, and know that we did have Jeremy and then Tom and Darla and I, along with Jamie and then Craig from our Neola rep, went through this policy. Jeremy, before I begin on this, is there anything else you want to add on the non-discrimination and from that?
We're on
meeting?
1422, right?
Yes, ma'am.
Okay.
No, I think you covered the highlights, Andy. Neola, for better or for worse, they organize all of their policies under the categories of people it applies to. So you have the student section, the teacher section, the administrator, et cetera. So that's why they have these. But they are making a move, I think, in a good direction of trying to consolidate. So I'm appreciative that they're doing some level of consolidation with these. The policies that Andy's pulled up now, the duplicative policies for each category of person, are not your big all-purpose non-discrimination policy. That we'll get to next. That's the 2260s that we'll deal with after that. These are more specific.
Yep. And so I'll just go through here. The first two pages gets into definitions. There was nothing on that page. On page,
What there kind of was, during our meeting, there wasn't, because there were certain parts of that we agreed we weren't gonna address because
the
we
opening
wanted,
paragraph.
yeah, we wanted the full board discussion on that. So when we look at the first paragraph, there was language in that first paragraph that we felt the whole board should come in front of. One of the things was because of the Supreme Court ruling and how they interpret the language, Jeremy, that's your forte. And what I think the other part of it I wrote in my notes was a protected characteristic and how does that apply and what we need to have in our policy. Jeremy, can you take that one?
Sure. It's my understanding that the law firm that drafts these or vets them, at least for Neola on a national basis, it's a large national law firm, starts by orienting towards federal law and state law for compliance purposes. The opening line of 1422 that I have pulled up on my screen in the packet as well quotes the Elliott Larson Civil Rights Act. They took that line that says the Board of Education does not discriminate on the basis of, and then inserted our state's law, which says you shall not, if you are a public body, discriminate on the basis of. So did that answer the question, Darla, in terms of?
So for our board policies, and I understand that Neola gives us these templates, they do all their due diligence, but they can be, and we do it at the board meeting, at our policy meetings all the time. We do make changes and we do make adjustments. So making an adjustment to anything would not be out of the ordinary of what we do for any of Neola policies. My question becomes, in the context of that first paragraph, is there any language that anybody would like to look at to change, alter, or do in any way? So the Supreme Court has ruled that,
I can recap it. So the Supreme Court has ruled that if your state has a law that says boys are not allowed to participate in girls' sports, that law is valid. It doesn't violate Title IX or the Constitution.
And these three policies are on non-discrimination, equal employment opportunity, and anti-harassment. So that's nothing to do with
Sports.
athletics, with sports.
it says in its programs and activities, and then it says including employment opportunities. So it does state in here, in its programs and activities. So I just want to make sure when we're looking at the language of these policies that we're doing it, we're looking at all of the language because some of these specifics do matter. And that's how I see it.
Jeremy, you interpret it that way? Programs and activities, do you see that as
Says it in the second paragraph.
Sorry, Brian, the question was,
So do you see the insertion of in its programs and activities? Does that take into account sports activities?
potentially, though that's not what this policy is targeted towards. The one thing.
Could it be construed?
It could potentially be construed. So the board is committed to providing a work environment that is free from prohibited conduct, responding promptly and effectively when it has knowledge of conduct that reasonably may constitute prohibited conduct, and addressing prohibited conduct in its education programs or activities. That's the phrase we're talking about?
Well,
So,
it mentions it in above in that.
In the first paragraph, sorry.
But it also.
oh,
mentions
above.
it again.
So the Board of Education does not discriminate on the base of race, color, national origin, et cetera, et cetera, et cetera.
Et cetera, et cetera. Bottom sentence.
In its programs and activities, including employment opportunities. I would suggest that it's a good idea for us to have, whether it's the Neola policy or a different policy, a statement of non-discrimination that says we don't discriminate in violation of the law. Because if we don't have that, we've opened ourselves up. Anytime somebody chooses to make a lawsuit, they're going to say, you don't even have a policy that says that you're not going to discriminate. Can I cut to the chase on what everybody's thinking on this one? So,
Please.
2 years ago, the state of Michigan added to Elliott Larson the last item on that long list within the parentheses there, gender identity. The rest of it's been the same for at least 2 decades. It's grown over time since it was first passed, but everything else has been on there for a long, long time and has been litigated at length. The phrase gender identity has not been litigated at length since it was added to the Elliott Larson Civil Rights Act, and I know that's the one people are thinking about. What does that mean? If we don't want to have boys participate in girls' sports at Monroe Public Schools, does this mean we need to change the policy? My legal advice to you is that no, it does not mean that, because I don't believe that, and there's no case telling me I'm wrong on this, so I'll just speak very specifically about what case law has not said, or what it has not said. Michigan courts have not said that passing a policy that says no boys and girls sports is a violation of ELCRA. That case has not been published. It hasn't been litigated. It's my position, therefore, and you're not the only board I've told this in public, I'm speaking on the record here, that until such time as there's litigation in a school talking about participation of students as opposed to adults in an employment context, that what does it mean to discriminate on, quote unquote, the basis of gender identity? It hasn't been defined through litigation in Michigan courts. And therefore, I don't think that it's required to delete that phrase of compliance to say we're not going to discriminate. I would not suggest that you add a policy, we will discriminate on the basis of gender identity, because then
We agree.
you directly said we're thumbing in the nose at Michigan law. What that actually means, and again, I have to speak very precisely, but what that means has not been defined by courts in a school context for students. It has been for adults in an employment context. So ELCRA, that phrase specifically, the Penske truck case is a published opinion from Michigan Court of Appeals that in the employment context, a private employer is not allowed in Michigan to fire a male who wishes to present as female in the workplace for the reason of that presentation. The court has said that that is illegal discrimination. A school case has not been published. So that's why if it sounds like I'm being technical, I have to be technical as your lawyer in terms of interpreting this.
Yeah.
I don't think that we should say we want to discriminate. That's not the answer. I think the answer is saying we're not discriminating, we're just drawing a rule, and no Michigan court has told us we can't at this point in time.
Jeremy, if we went to that sentence at the very end and took out the words programs and activities, including, so it just read in its employment opportunities and left everything alone, we would be in compliance, and then we're not at all talking about programs or activities, we're talking about employment only.
The rest of this policy would not have anything to say about sports at that point in time. That's the only phrase that could even be construed, to Brian's point, to encompass anything
So
else.
if you focus on the non-discrimination statement, it would be everything as employment only. So you take out the words programs and activities and the word including.
That's what I was unclear about, because Jeremy was telling me that, it seemed like Jeremy was saying you leave the programs and the activities in there.
So
So I'm missing something that you were saying.
what I was
Didn't
suggesting
understand
is
it.
that the way they've drafted it, the policy is about things other than your sporting programs. However, I think the follow-up question you had asked me was, could it be construed to say that in our programs and activities, could that be construed more broadly? And I think the answer is yes, it could be construed more broadly. Somebody could.
Your recommendation would be, it would be okay to remove it as long as it obviously has the phrase employment opportunities.
I don't think it would alter the intended meaning of your policy if you deleted that portion, no, because it's about employment.
Okay.
I think that was the other part was what these each focus on.
Yeah.
And in the second paragraph, it also says education program and activities. So it says the commitment applies to all district operations, and this policy applies to prohibited conduct occurring within or as a part of the district's education programs and activities. So are you suggesting to do the same thing in that paragraph that you're doing in the first paragraph?
I would just say, keep these policies focused specifically on hiring.
So take that out of there as well.
So it's in the first, second, third paragraph, or third sentence. Does anybody see it anywhere else in the?
We will actually do a wordsmith there of it to make sure it's captured, because things like this pop up throughout policies we found. Keep going.
That one seems to be a little more specific in it. It has some specificity to it, education programs or activities. The other one does not have any specificity to it. It just says programs and activities. No difference as far as from a legal standpoint. I'm just trying to make sure
Neil
that.
does this a lot.
I understand. Why were they specific about, in that particular paragraph, they're very
He
specific
would love our
about
committee meeting,
education programs.
wouldn't he?
So,
Oh, sorry, go ahead, no.
no.
I'm not a board member, go ahead.
So, if we're gonna remove that phrase, then we need to remove the definition of education programs or activities from that entire section.
Where's that at?
It's in the definitions portion,
Page 2.
education programs or activities, there's a whole definition of what it is.
And athletics is part of that.
Yeah, there's a lot
And
there.
that's, and I'm not trying to play word games, I'm trying to answer the questions directly. I wasn't suggesting that I think it's a good idea to delete it. I think that in that first paragraph that I was asked about, if you deleted it, it wouldn't alter the meaning of the policy. The reason that the definition includes sporting programs is not because it's about boys and girls participating, it's because you have adults who are employed to work in those parts of your program. So that's part of your HR policy, for lack of a better term. I don't think there's a need to strike it myself, but that's just my opinion.
Even in the first sentence, it says in its education program and activities, there's 3 times within 3 sentences, it's using the same language. I don't know if it's using it in the same capacity in each one of those. Maybe that's what the difference is, Jeremy.
1422 deals with employment, and then what about the other two? The 3122?
They're all employment, so you have one like.
They're all in.
First one is administrators, the next one is professional staff, i.e. teachers, and the last one is support staff. Yep.
Can you give us an example of a protected category that's listed in that first sentence?
In the very first sentence? So starting with race is where the list of protected characteristics are. So race, color, national origin, sex,
Oh, it's just like,
sexual orientation, gender identity, disability, age, religion, height, weight, marital, family status, etc. So I think genetic information was the most recent prior edition before the 2024 edition of gender identity. I believe that was done in 2010, something around there.
thank you, I was reading that as a summary, I thought that was, or any other
Right.
legally protected, like there was more.
There
Yes.
is.
So the law says shall not,
Another legally
yeah.
protected category, collectively protected class.
I think
Right, so
I
that's
think
what I was
there's
asking is.
What is
something
that?
gets added.
the law, they quoted, they just, Varnum, the Chicago law firm, just went and pulled that from ELCRA. The list in ELCRA says shall not discriminate. In and of itself, that doesn't mean a whole lot, and that's why the answer, and that's if it sounds like I'm being really lawyery, I am, that's because the answer to what does that mean comes through litigation in terms of people saying, so if we say shall not discriminate on the basis of race, we'll pick a less hot topic, a closer to home one. In the mid-90s, this is far enough in the past, I don't know if anybody here is a member of the DAC. the Detroit Athletic Club was since its inception until the 90s, an all-male club. And there was a lawsuit in the 90s that said that policy, which is a private organization, violates ELCRA because it says shall not discriminate on the basis of sex. Well, it wasn't self-apparent what that meant, shall not discriminate. The members said, we're not discriminating, it's a private club, we just want to hang out with each other. And the court said, no, that is discrimination. So that's why when I say in the context of gender identity, the courts haven't ruled, that means a lot to me because they haven't addressed what does this mean in the context of a school for students playing sports. They haven't done it yet.
I just want to point out, it does not say, it says the Board of Education does not.
Does not discriminate.
Yeah, it doesn't
Yes.
say shall not. Is there, you
No,
were saying shall, and we're like.
Forgive me, does not.
Okay, but yeah, in lawyer stuff, don't they mean different things?
Potentially. That was a misstatement on my part. It
No, that's
does
okay.
not discriminate. So you're stating your policy. We don't believe that we should be violating Michigan's law. That's the paraphrase of that list. Yeah. In each of these employment contexts.
Okay, so for clarity's sake, on page 1, I need one of my board members, please tell me what we're doing.
I'm as clear as mud.
Thank you. Okay.
Somebody else?
Yeah.
Somebody else?
I don't think that we should do anything per what Jeremy recommended.
It seems like it's all related to employment.
Yeah,
Sure.
I mean, that's the title of
Yeah.
the,
So-
Non-discrimination, equal employment.
yeah.
There's a spelling error in the first paragraph, second sentence. Related.
Just to be clear, though, in paragraph 1, Jeremy said that programs and activities could be construed to be,
But if it has to do with employment.
Employment, yeah.
that's what we believe.
I think we
like,
take
when
it out of
does
the first
mention
paragraph.
Athletics, it would be.
You did not have a problem with us taking out of the first paragraph,
No.
correct?
I'll repeat myself very
please.
simply.
I'm sorry.
No, that's okay.
It's a lot of drive time.
Rather than speak in terms of problems or not, but it's not my job to have a problem. So no, I don't have a problem. What I had said was I don't believe that in the first instance of that, the last line of the first paragraph, I don't think it would alter the meaning of the policy because it's still about employment policy at that point in time. If you get into altering the definition of down, as Mary pointed out, under E and farther down below there, that would start to
Yes,
Yeah.
tend towards.
understood.
Okay.
Yep.
But the other two times the exact language is used in the next paragraph is not a definition, does that matter? To be consistent, because a lot of times we.
I'll
look at
try to,
this-
yeah, and I'll try to be, I don't believe you need to make any changes to the policy, including the first line. I don't think it's necessary. The answer to Brian's question was, if you did change it in the very first line, I don't think it would mean much to the policy. I think it wouldn't alter much in the policy. Once you go past that, it will start having impact on how the policy reads.
Okay.
Okay. So on page 1, we would be removing the words programs and activities, the comma, including. So it just reads, in its employment opportunities. Correct? That last line of the first paragraph.
And correcting the spelling of related, as
Yeah.
Stacy mentioned.
Where we see showing,
Yeah, related.
no, what was he showing?
What's that?
I was looking at the highlighted, look for the highlighted marks on it. Is it highlighted?
No. That.
Okay, I'm
that-
like,
this is
what are
my-
you looking
This
at?
is my set of notes.
You see
from the
mine?
meeting.
I
Yeah.
got this one all written
I'm
up,
working
I
off
got
2
this one all
documents right
written
now, so I'm just going back, because I already did some other.
On
part.
page 1, you said what?
Yep, so on page 1, first paragraph, last sentence,
We're gonna take out.
you're gonna
Oh,
take out
you
the
are
words
gonna take-
programs and
That's the only thing
activities,
that gets taken out.
including,
Yeah.
okay?
Okay.
The rest of page 1 is left alone. The definitions are left alone. On that third page, there was an option underneath 2A. The recommendation to the board was to not have in there and obscene gestures. There were no other recommendations on page 3. There were no other recommendations on page 4. On page 5, when we get there, underneath supportive measures, we did say referral to employee assistance program. That was checked off. Further down, on non-discrimination based on employees' genetic information, there is we would be taking, the district recognizes that genetic information may be acquired through commercially and publicly available documents like newspapers, books, magazines, periodicals, television shows, or the internet. The district prohibits, however, its employees from searching such sources with the intent of finding or obtaining genetic information or accessing sources from which they are likely to acquire genetic information. On page 6, we were recommending to not take at the middle of the page that section there.
This is what we do in the policy committee, if
Yep.
you're wondering.
Yep.
This is where all this come from.
We go through a lot of these things there. So if something, because I know you guys had this ahead of time, if there's something that you had a note on and you have questions, please ask. We go to the next page. That's where we got into, one of the things we are working on creating, the address will be placed in there, but we asked for a specific a specific email address. And that was requested, so we're working with, we'll be putting in there a specific email address.
Are you on
here.
page 7?
I am on page 7, ma'am, yes. And so these stay, all that, you see highlighted, executive director of HR, executive directors of secondary ed. So that way there's a second district compliance officer, and they're named.
But the other reason for that was, and we don't have that listed in here, but there was a note that Neola recommended there be a male and a female in that category. We have the ability now, because there is one,
Yep.
that down the road, if that would change, that would have to be altered in that. I don't think it's specifically worded in here, right, Andy?
No, but you're exactly right. That's our intent, is to have one female, one male person as compliance officers.
It's just not written into the policy.
And then the board designates the executive director of human resources. Oh, yes, ma'am.
The human resources at Monroe.K-12.
Yeah, so.
Just a catch-all?
So what we wanted to, so the conversation was to have an email address so that it wouldn't get lost. And so that was one of the conversations that we had, was a very specific email address, so that so it wasn't just a catch-all, because that's one that's just a catch-all for all. And so we want to make sure that there's an email address that was used, that nothing could get missed. And so,
You didn't actually put that in here.
no, we've got to put that together. So then you can see that this another area that we accepted was the district compliance officer may delegate specific duties to one or more of designees, so that way the work can be done. And then we get into areas that we did not accept. Same thing on page 8, going through, you can see the items that were accepted, thought that was appropriate, and then those areas that were not. So I'll take a moment if there's any questions on remaining 7 or 8.
Yeah, to go back to the designee of the executive director of human resources, that was a choice that the committee, everybody sitting there decided would be the person that made the most sense for oversight of the board's compliance. Made sense to us. Make sense to you? Okay.
So
Now that your signature's on there, right?
going to
Now we
page.
can talk with you.
Going to page 9, looking at page 9, we just said no to the administrative guidelines there. Same thing on page 10.
Didn't we check mark back there, the board president too, the district compliance officer shall report directly to the superintendent? And then we also, the CEO shall report directly to, we put the board president in there.
Get that.
Yes, it is.
Just for everybody to make note of that, we did include that in there as well.
So 9, page 10. Good news, everyone, we're already halfway home through this one. And then we hit page 11, which has a whole lot of activity going on. So on page 11, this one, at the beginning, you can see areas that we accepted. I think the biggest thing we got into right here were timelines. The only thing that wasn't added on here that would be is business days. So that was one clarifying item we wanted to make sure was added there. So for example, evaluation, district compliance officer will determine whether to dismiss a complaint or investigate it within 5 business days of receiving the complaint. And then each item down through, trying to be consistent on our days as we go all the way through these different policies, but making sure we use the word business days in there so everyone understands that side. So the investigation will be 15 days. However, the CO down, if we go down a little bit further, however, the CO or designee investigator decision maker determines that the investigation is going to take longer, the CO will also notify the parties and the superintendent and will therefore keep the parties and the superintendent informed of the status of the matter every 5 days. Again, expectation that it's moving along. Then the appeal process is 7 business days. Then we did not take the next part. On page 12, we said yes to the board's grievance procedures and information resolution associated with the claims involved in the prohibited conduct. Next page, on page 13, did not push in the administrative guidelines. I did not put a note there. I think is there one of our people can remind me why we said no on those so that our board members understand.
Which one?
On when we everything where you see the cross strikeouts of administrative guidelines. So there's a lot of places.
Oh, yeah. Yep,
We
14.
don't publish those publicly,
Yes.
so that is why we took them out of our
Yeah.
policy.
Thank you.
Where?
Right up here. Administrative.
Where, for example, on page 13, you
D.
see where it's crossed off on page
Yeah.
AG 1422.
Yes.
Yeah.
Yep. Thank you, Jamie.
I have them.
Page 14.
Her, Jamie.
Page 14, notify the parties in writing of the determination whether prohibited conduct occurred, including the rationale for such determination and the procedures and permissible basis for the complaint and responded to appeal. So that was accepted there. We struck out and did not take the option of including notification of the complaint of any such disciplinary sanctions. And the reason being there again is employee rights, and we're not going to push that out. The appeal of determination, that was 7 days. And again, Jamie, can we make sure on those that we, everything
Yeah.
on it with the days goes to make sure
Consistent.
business days are listed in there.
Yeah.
And then draft note where the board, it said the board may insert additional grounds on which an appeal may be filed. And the recommendation from the committee that worked on this was to not take letter D or create any other options for appeal. And then the recommendation two of the group was to, the complaint may not challenge the ultimate disciplinary sanction consequence that is imposed. Darrell, you had a question right there?
Yeah, when we talked about D, number 2, we talked about not notifying disciplinary sanctions. We did talk about that ensuring that it's like ensuring that we have handled it according to all of our policies and
Yep.
procedures,
Yes,
that
yeah.
that language would be,
Okay, yep. So I see a note here, handle with the policy applied with the facts that were
Gathered.
gathered.
that were gathered.
Yeah.
And I don't see that in
Yep.
there.
That will be.
We thought that was important,
Caught.
because if
Yeah.
you don't get information on
Yep.
what happened, at least you know, hey, we did it, we get it, you're not getting it.
Yep. So that's, I've got that in my notes too. Thank you for that catch. We'll put that in there. And as a reminder, board, this will come back out to you with the business days on there, any other adjustments. I saw from example, the first page, so that your eyes will have it. And then once you're all set, then it's publishable to the community for that first reading process.
Can you please give us that additional text that you would like to add to D2 on page 14?
Yep. So I want, Tom and Darrell, to make sure I've got this right here. So this was underneath number 2.
Yeah.
Coordinate the imposition of any disciplinary sanctions on the respondent and handled with the policy.
And has been handled with the policy and the facts gathered.
In accordance, I wrote, has been handled in accordance
in
with the
accordance
policy
policy, yeah.
applied to the facts that were gathered. So it was important to say the facts were gathered, we got them, and we're handling it within accordance of policy. We can't tell you what we did, but we just know that we did handle it and whatnot. That was the suggestion, right? That's
I
what
appreciate all that clarity because that's now on audio right here for us to make sure we
Yes.
get it explicitly that way.
That was the intent behind it as well.
And we'll do a little bit of wordsmithing with it so it reads smoothly.
Yeah.
Okay, right in there, but I think you have
Stacy had some.
the idea around the.
Yeah, I'm just gonna say that day or days is in our definitions.
Oh, is it?
Yes,
Of
Days means business days.
yes.
Oh, is it already there? Okay.
It's in our definitions.
Thank you.
Well, then never mind on that other. Good catch.
Good job.
Appreciate that.
Good job, your kid.
All right. That was page 14. Now we're on to page 15. And page 15, you see the items we did not take. Then we had their parties provide a reasonable and equal opportunity to make a statement support of or challenge the dismissal or determination. That is 7. The number 7 was inserted in there for days.
At the very beginning, we check marked, the complainant may not challenge the ultimate disciplinary sanctions or consequences, which makes sense based on the previous one. But in the Neola drafting note, I'm highlighted, if the board wants to serve as an appeal decision maker, it should discuss this issue with its legal counsel through option 1 of option 2. And then we after that, put option 2. So just make sure when you look at that to agree with kind of how that was put together. Because in our previous or current, however you want to look at it, process, who is the appeal person and how does that play out, I think was important to the board.
Yes.
And again, remove the administrative guidelines.
Yep, underneath option 2. Page 16, as we went through this one, you'll see that option 1 was not taken, option 2 was. Here, where it's notify the CEO in writing the results of the appeal and rationale of the outcome. The CEO will then simultaneously notify the two parties, the parties in writing the results of the appeal and appeal decision makers' rationale for the outcome. And no on option 3. The appeal of the decision makers' decision shall be final. Was that option there?
I also want to point out in option 2, it says that the superintendent is the appeal decision maker unless
Yeah.
they've been involved in the grievance procedure at all.
Yep.
So that, just to make a clarity there, like it's, if you're involved at all, then you're not going to be that part of it.
Yes.
I thought that was important too.
Appreciate that. Page 17. So when we get in here, on page 17, we did take, up at the very second paragraph, the assistant, referral to the employee assistance program. With disciplinary sanctions, we accepted oral written reprimands, and then demotion and or reassignment, suspension without pay, termination. And so those were the ones that the group felt were appropriate. The other ones required counseling, required training, suspension with pay. We're not suspending a person with pay. If there's a disciplinary sanction, it's going to be without pay there. So that's why we selected the ones we did there. Good news, on page 18, there is no recommendations to you. Page 19, on page 19, application of the First Amendment. We did not take either of the two options there. And then underneath training, we did not take any of the options that they provided to us also. Further down underneath letter C,
Can I ask a question?
yes, ma'am.
Can I ask why the principles of academic freedom as set forth in the applicable collective bargaining agreement wasn't selected?
Where are we at?
On
So application of the First Amendment, it's the two items that were not selected.
Right here.
Yeah, that's on page 19, Darla, at the very second.
Oh,
paragraph.
because it starts on the other page. Okay,
Yeah,
I'm
Word
sorry.
will
I think it was because, wasn't it already set somewhere else in there?
I,
Yeah.
I have the answer to that one. So I wasn't part of the conversation on the selection, so I can't answer that part of the question. But the collective bargaining agreement with the teachers does not have any reference to academic freedom. The closest we get is protection of the freedom to learn.
And I think one of the things we tried to in this policy was, as Jeremy said back on very much page 1, we're going to follow law and leaving it there. And that's what we tried to do is what does the law say? And we live in that space.
Yeah, and that part is specific to the First Amendment, so
Yep.
you'd be throwing in something not related to that.
Yeah, exactly.
And we didn't choose that training was because of the way it was, like,
Yes.
it would have
Yeah.
put constraints where constraints we didn't think were necessary.
Yep. And then administrative guidelines not there. And then on the last page, we did not recommend taking that, and that's, read that drafting note. The following option expressly sets forth authority that the board has, regardless of whether it is included in this policy, but is offered for those boards of education that may want to affirmatively communicate to address these issues for readers of this policy. And it's already, authority's already been given to the board, so
Through our
why?
bylaws.
Yep, so why add
So we didn't need it here.
more to it?
We could have said refer to bylaws, but it wasn't necessary.
There's nothing random tonight.
So I'm sorry, I'm going to take us back in time. So
Okay.
if we go back to page 6, just a question about the wellness program initiative paragraph that was taken out. Just because the reason I'm asking is I know that our wellness initiatives were once something that were offered quite regularly. Just curious about why that verbiage in this policy was removed.
We still have it. It's somewhere else, right?
Yes, but this, if we look at this whole section right here,
It's health services.
The,
But it's also including the wellness program.
so this refers to the whole thing of genetic information. And I think that was when we looked at it is being specific to what our wellness, what we can actually do.
Right. The
there.
last part of it, but only genetic information in aggregate form will be provided to the board.
Right. But
Like that
there's
makes note.
But there's two options there. The first option ends after the wellness program. The second option is the one that talks about the genetic information. So that first
Okay, I
option,
see
the
what you're
district
saying.
offers health services, including a wellness program, end of internal option. Boop.
Well, there are two options there.
Right.
First is,
So my question is specifically about the first option, about the wellness programs.
I thought they were listed somewhere else. Are they in contract, Andy?
So participation, okay, I see what you're at,
Yeah.
including a wellness program.
You're just, Mary, discussing that first sentence, the district offers health services.
Yeah.
Yeah.
Is,
Health
Program.
services, including a wellness program, end of internal option. I'm talking about that very first sentence. The second sentence I understand because that talks about the genetic information.
yeah,
Well, this entire section starts out, it's non-discrimination based on
Yeah, I-
employees' genetic information. So everything in those paragraphs are related to genetic information, which is why we would remove that because it's all related to genetic information, of which we're not gonna, involve ourselves in. Because it's already done, right, Jamie?
Yeah.
I'm actually pulling out the one second.
And that- to me, that sentence by itself has no relationship with non-discrimination. It's,
Yeah.
to just say you offer health services, if it said something like you can't discriminate with health services. But by itself, it doesn't seem to add anything.
And there's two options there. There's an option that, there's two parentheses. So Jamie's gonna pull up any further notes that we have on that.
So this is mentioned somewhere else, though. The district offers health services, including a wellness program.
Wellness is
Mentioned
addressed
somewhere else.
elsewhere.
Okay.
And Andy, correct me if I'm wrong, where's Cindy?
So,
Isn't it in their, who knows this? Isn't it in their contract that there's services that are offered?
there's a.
Because this is all non-discrimination.
There's
we're
a
not-
very, I don't want, I'm gonna be very careful because I know I'd have to find it I'm trying to find it very quickly.
In this policy, Andy?
Yes, I want to get to the exact term. There, so just give me a half a second.
Because this is all.
I'm reading through trying to read through the transcription, pertaining to that particular.
Note there.
I believe this one was removed because it was under the less is more,
Yeah.
status.
Mm-hmm.
Let's see, we do not have a wellness program built in,
With genetic information.
correct?
Yeah,
And I think that was the biggest key.
yeah, we don't have it.
Yeah. I don't know. I think that the other part of that was, do we want to involve ourselves in this genetic component of things?
What is aggregate form?
Yes or no?
Without personally identifiable information on it.
You don't
Yeah,
have any
I go back to, I believe it really had to do with less is more, and at the end of the day, we do have employee assistance program, there it is. Oh,
Yes.
So, yes, we have the employee assistance program, but there's not a wellness program. That'd be all.
Okay.
So I think if you read through the whole, because this has to do with the genetic and not discriminating based on it, I think it's saying that if you do participate, your genetic information may be obtained, but it won't affect you.
We can't request it.
Yeah.
It says, but only genetic information in aggregate form will be provided to the board.
I don't want anybody's
She said
genetic
it's-
information
Yeah.
It's not
personally.
identified.
Yeah, why would we?
I'll pass on that one.
Yeah,
But I wasn't there when they mentioned this.
that's kind of, I think, the why. That helps.
Why would we want
I just think that that's why.
Yeah, I think just leave
Stressed
it,
out.
it?
just leave it out
Yeah.
there.
Yeah.
Any other questions on 1422? So what will happen now is with 1422, 3122, 4122, we'll make all the fixes. That'll come out to you this week so you can see them. And then that will be part of then that next set of first readings on those policies, so they're done. So now, policies 2260, and then these other 6 policies are being rescinded. So what they did is they combined them to get rid of those, okay? Now, in 2260 and 2266, this is where technical corrections is what it boiled down to, and we wanted to really come back to you because in these policies, as we stated before, this had to do with the Supreme Court and what had transpired with the Supreme Court. And so we wanted to give the Board of Education an opportunity to have a conversation. And so 2260 is where we would start there. And so Jeremy, I want to just kind of hand it over to you, please. Non-discrimination and access to equal educational opportunity.
Yes, so this policy has been talked about a few times recently, and I've had some questions from various board members over the last year or so about this policy, and there's been suggestion that you may wish to overhaul this to make it clearer, easier to follow, easier to understand. So I'm very happy to support you in all of that work. The Supreme Court case that we were all waiting on, because nobody knew until it was published exactly what they would say. It's the way they work, and they tell you what cases they're going to take, and then you wait, and then you get their decision. So we waited for the Supreme Court case, which we were waiting for, and we've got it. But again, I'll just recapitulate what they did rule on, and then what they explicitly said, by the way, we're not ruling on. And the first footnote in the case says, we're not addressing what if a girl wants to play on a boys' team? Not addressing it. What do you do about bathroom usage? We're not doing it. I'm paraphrasing, but this is what the footnote says. What they ruled on was a state law that says no boys and girls sports is valid. It does not violate Title IX, and it does not violate, it's on, I don't know what page. Oh, the document, it's page 98 of the 120 page document. 2260 starts on page 98 of the PDF. So they said the state law that says no boys and girls sports does not violate Title IX, does not violate the Constitution. And that's as far as they went in terms of their ruling. So they didn't specifically rule on a board policy. They were not addressing a local board policy. A couple things I would say that can be reasonably inferred as guidelines for us from that Supreme Court case is that to the extent we do any kind of new rulemaking, any new policy of any sort, that we speak specifically in the terms the court used. So the court talked about biological male participation in female sports and female sports spaces. That's the language that the court used. The reason I point that out is that and this is not a criticism of anybody either in this room or anywhere else, but in common parlance, people talk a lot about transgender participants. Even MHSAA was speaking in their press release about a quote-unquote transgender participant. The court did not use that language, and it made a point of saying, and it's about halfway through the opinion, that the decision of the court was not being shaped based on the idea of transgender status. It was based upon the idea that a law, in the case of the Supreme Court case, making distinctions on biological sex did not inherently violate Title IX or the Constitution. So that's one thing that I would suggest is to the extent the board considers any kind of modification, I would not speak in MHSAA language. I would mirror the language that the court utilized to the extent that you are considering doing anything with it, and talk about biological sex and whether you do or don't allow biological sex to participate in the opposite sporting program. That's the first thing I would say with that. I believe, as of today, that you can do that, if you choose to do that, without explicitly violating the Elliott Larson Civil Rights Act. There are other attorneys who disagree with that opinion, chiefly, well, MHSAA has clearly gotten that advice. That's the position they're taking, and the ACLU, and I only mention that not to harp on them too pointedly, but they have a team of lawyers devoted to this issue, and I've seen the letter that they write, so I know that it's a live topic. They take the opposite position, and others do as well, that despite not having any rulings in Michigan, that they just interpret ELCRA, to mean that you can't do anything that would deny a person the right to act based on their own self-expressed gender identity. Again, the Michigan courts have not said that yet, and until they do, or if they, as long as they don't say any such thing, then you don't have a direct conflict between adherence to, for example, the president's executive order and Michigan law at this point in time. There doesn't have to be an explicit conflict. It could be read to be a conflict, and we may reach a point where the courts litigate in such a way that there is a conflict, but it hasn't existed yet in a technical sense. It's all a long-winded way of saying if you want to look at drafts of different ways to restructure this, you probably can, and I'm happy to try to help you sort that out if you'd like to.
So we could ask you or your team to reformulate policies that would include the language for which you just said that's something you could do.
So I'm happy to take direction from the board. What has been suggested to me by various board members at various times is a couple things about this policy. One, that it was written in a way that was too confusing and hard to follow. I've had a couple board members express that. I've had a couple board members express, and that's not a specific topic, that's a structural point that was made. I've had a couple board members suggest that it would be helpful to have a flow chart. If you are starting here, where do you go next? And I can see the benefit in that. I understand that as well. And then a couple of board members have asked, I don't know if anybody's suggested it. I'm being careful with my language, so not to attribute anything to anybody improperly, but I believe I've been asked by a couple of board members whether it would be possible to look at saying something that we do not allow boys to participate in girls' sports and girls' sports spaces. As of today, I think you can do that without directly violating Michigan law. If a court rules opposite in the future, then I will have to make you aware of that at that point. But as of today, that case doesn't exist. So.
I think drawing something up that includes those points that you just mentioned, the flow chart, those three components that you mentioned, and bringing it and saying, what does that look like? I'm a proponent of that. I can't write this, and I didn't want to try
And it is a very confusing,
legally.
complicated, as we tried to figure out what the appeal process was.
So if the board would, if I can just help with the verbiage, if you asking if we can work to provide a simplified draft that it covers the same legal ground, that includes suggestions for possibilities on the prohibition of boys and girls sports. And do you want me to try to take a stab at a flow chart as well? Is that something the board would like? We can definitely take a crack at that and get you something to
We
look
would
at.
appreciate that.
Because that way it covers all the legalese for which we don't have the ability to do that. But
I'd be
to
happy.
include those components, is that what we're suggesting?
Yeah.
Okay.
I'd be happy to work on that for you.
Okay. And would that be the same case on 2266?
Yeah.
Both 2260 and 2266 are very similar
Yeah,
in nature.
they could look very similar.
Is it 2266.1 to do with disabilities or something?
So yes, the various point is how Neola differentiates
2260.
different subtopics. So yeah, I was just, so 2260 is your general all-purpose non-discrimination package. 2266 specifically, it's titled non-discrimination on the basis of sex and sex education or in education programs and activities, Title IX policy. The content of it, again, for reasons that have evolved out of litigation on a national level, is all about sex harassment. So this one, I would not, I can make some suggested revisions that I think would refine this and make it hopefully a little more clear. I wouldn't expect nearly as much markup on this one because the requirements of process are explicitly in place. We're operating, I think I mentioned this previously to the board, but I'll just recapitulate briefly. The 2020 or the 2020 regulations from the Department of Ed and Department of Justice were suspended during the Biden administration and then were re-implemented during the current administration, I believe on the first day of the current administration. And so we are operating on published federal guidelines that are in the Code of Federal Regulations for how you address sex harassment. This policy does reflect that accurately. I think it's aligned with the regulations. You could probably simplify it a little bit and make it a little bit easier to read. So
Your 2260.01, is that the one you were referring to?
Yeah, that's the disability.
Yeah, that's the section.
I wanted to address that one, but on the one that you just,
2266?
yeah.
Okay.
During the investigation, and I'm trying to just look at a process, were there more than one application for a Title IX issue other than sexual harassment? Does it, do you get it? Does that make sense?
I'm not sure if I understand.
So is Title IX strictly sexual harassment, or is there other things?
Oh, gotcha. Yeah, no. So Title IX is bigger than sexual harassment. It's not to. I will not digress too long, Stacy. But when it was passed, she warned me at the beginning: don't talk too long about things when you get the microphone. It's a fair reminder. I take it in the right spirit. When Title IX was passed, it was explicitly about access to programs, specifically athletic programs. It was not shaped as an anti-harassment law at the time it was passed. That said, so technically speaking, and I'll try to make this a verbal flow chart, Title IX prohibits discrimination on the basis of sex. The courts have developed over decades since that law was passed, and as the regulations have been updated to implement Title IX, have developed the idea that harassment can be a way to violate that prohibition of discrimination. The theory and the legal standard is if the harassment is so pervasive and severe, that's the phrase that's used, pervasive and severe, that it inhibits a person's ability to participate in your programs, then that has the same effect as if you had told them you can't participate in this program. So that's how harassment fits under the bigger title of discrimination. The reason we have a specific policy that talks all about harassment as opposed to big picture discrimination under this is because we have a federal regulation on the books that says you will have this process for if somebody alleges they were sexually harassed, this is what you do about it. And that's why we have a 2266. But it fits under the bigger picture of the prohibition on discrimination.
So this policy covers all of that. Because, you know, in those circumstances, I didn't even know some of that stuff. And
So it's interesting. It's very unusual, statistically speaking. I mean that in a technical sense. It's not common for a school district to get a claim that says I was discriminated against on the basis of sex. That doesn't happen very often. 99% of claims that come in the door where somebody says I have a Title IX issue are a sex harassment issue. That's mostly what schools have to address. And so one thing that we might want to make clear in here, and I think we can effectively do in your policy if we write this in such a way, is to make clear if you aren't saying you were harassed, but you think that you were discriminated against, here's how we're going to address it.
and that would follow the same process that you're putting.
It would probably follow more the process in 2260, and I think we could make that explicit. The reason I say that is 2266 reflects the federal regulation that is explicitly about harassment investigations. And you could follow that in the alternative circumstance, but it's such a detailed, very technical process that I think you would be imposing a greater burden on yourself than you legally have to if you said you're going to do any claim of discrimination according to the harassment model.
And you can just take care of that when you're taking care of everything.
I'll try to draft it that way.
It's working out.
It's going to be your decision, but I'm going to give you some
Beauty of having
suggestions.
all this
So-
recorded, it'll be a transcript given to him, so on that. Darrell, you did have a question on 2260.01, section 504 ADA, prohibition against discrimination based on disability.
Yeah, the reason I went looking at this was, and we didn't know about the current program that you're utilizing at the middle school for students that, I don't know, the program that you're doing now.
Emotional impairment.
Yeah, so that would fall under potentially a disability. So how does that, and Trojan Academy was the other one that falls under this. How are those two programs with this policy? Because there's a lot of stuff in here. So I'm just making sure that not only what we're doing fits the policy and what we have in our policy meets all of the discrimination. Because like, if you can see my notes,
Yeah.
I made tons of notes through here on this policy, so.
So the long and the short of it is that special education is, the idea around special education is you move the bar up so everything is equal for all kids. That's what special education is designed to do. And so if a student, section 504 ADA, prohibition against discrimination based on a disability, this policy is really saying, and this is where I think where parents will turn, and I know I'm going to turn this over to Jeremy in a moment on this, is that this is where they're going to turn if they feel like their student isn't being serviced appropriately, and they have a disability. It could be, for example, a really simple one is, I look around, a lot of us have glasses, right? And if we have a 504 plan because of our eyesight and a teacher's not following that 504, then there's this process that's placed in here. So it has nothing to do with specific programs that you run or do not run. It's all about the students and what's going on with the student. Did I capture it closer?
I think so. If I refine it just slightly, so the two big laws that are implicated by this policy and that we have to comply with, you have IDEA, which is broadly speaking, covers federal requirements for special education law is the way we talk about it. And then you have section 504, which is what this policy is specifically calling out. They're oriented a little bit differently. So IDEA says if a student qualifies, and the reason I'm calling that out is I think it gets to some of your questions, Darla, about if a student is evaluated because we've identified maybe a student has some need, whether it's an emotional impairment, a cognitive impairment, whatever the case might be, some type of disorder. These are diagnostics. And so when a student is evaluated and qualified to participate in a program under that, that's about the individual's needs, and it's going to be pushed down to the student to meet them where they're at. 504, and that can mean a lot of things. I'm trying to be fairly general. 504 is an access statute that essentially says you run a program, and if somebody has a specific barrier that doesn't let them participate in the program, you have some level of obligation to remove the barrier. And we memorialize that in a quote-unquote 504 plan. So if a student has an emotional impairment, for example, they're going to be under IDEA. They may also have 504 accommodations, but it might be more common that you would have a student, to use Andy's illustration, if somebody has visual needs of some sort, we're going to let them sit in the front of the class so they can see the screen easier and their glasses can focus at that range or something like that. And other things like that. And that would be written into the 504 plan to make sure that everybody knows. The plan is to make sure that all of your staff can provide that barrier removal in the appropriate context as you go through the day. But neither of those are targeted towards a specific program that you're running in terms of, we're going to do emotional learning or whatever the case might be at these various things. They're attached to the needs of the students. And so I'm not sure if that answers the question, but they're not really, this policy isn't really about targeting a specific program that you offer or a type of programming that you offer. It's really about the students' needs.
Yeah, because I was looking at the paragraph on page 2, and when it talks about vocational educational services, it says the board will not deny a student with disabilities access to its vocational education programs or courses due to any architectural or equipment barriers or because the students needs relative aids or services to receive an appropriate education. So my application to the constraints in these programs, because remember, we're going to bring in the little pyramid from the state that says more restrictive environments, and these environments are becoming more and more restrictive, which used to be less restrictive, and now they're becoming more restrictive. So when it has a policy on disabilities, and now we have these more restrictive environments, how does that affect our policy? Because we have a lot more restrictive environments that we didn't have before.
It shouldn't implicate your policy at this point in time. So a student who's been evaluated for special services and has been found qualified for the special services under whatever qualification category that is, will have a team, the IEP team, assigned, and that team is charged by law with determining the least restrictive placement for the student, whatever that is. And that can mean a lot of different things in a lot of different contexts, depending on the needs of the student that are identified, depending on the programming you have available or the county has available, et cetera. But the team is supposed to make the determination of the best place for that student in the least restrictive environment that will be able to provide for their needs at that point as identified. So that shouldn't require any sort of policy change from you.
Because those changes made me wonder if we need to change policy.
So I want to bring clarity to tonight. So the clarity is we will make the adjustments on the 22 section 3 policies for you. The 2260 and 2266, Jeremy and his team will go to work on rewriting those policies and then bring them back. We'll have a meeting on that to go over those. Those policies would replace Neola and be specific to really to Monroe Public Schools. And so they'll get on that in a timely manner. And then we do have a
No, that makes sense.
policy work coming up for you where we want to go through some policies that were already done. I think we slated that for early August, if I remember right. But we'll be going over the board work sessions next Monday night, and so that'll be brought out to clarity so you guys can, you can see those policies there. Is there anything that we missed, anybody?
So, from my understanding, and correct me if I'm wrong, that the rewrite of the two policies that we're looking at, the 2260 and the
66.
thank you, 2266. That when it comes to the verbiage in like the opening paragraphs, we're not necessarily editing that content. It's more of providing additional content later on in flowcharts and things. Yes?
I think that's the direction that I would suggest going.
Thank you.
But it is going to address the biological male and the biological female in their respective sports.
It's my understanding that the board would like me to present you language that you could consider, though it's the board's decision to discuss that.
Okay, I just wanted to make sure that was clear, Mary understood.
Yeah.
And I should clarify, I'm not going to set your policy, but I will give you what I think you've asked for in terms of something to look at.
For us to review.
But just, I know that previously the terms gender identity were things that other board members were concerned about.
I would, at this point, it's not my suggestion that you delete the line at the beginning of your policy because it does reflect accurately what state law does state. My point in contest to the ACLU, among others, is that we can have a no boys and girls sports policy without violating the law, and because it hasn't been litigated otherwise at this point in time.
And that only addresses participation in Monroe Public Schools, not a team
Yes.
coming in.
Right. And the other language questions were just a clarification on the Supreme Court ruling and if it impacted that at all. And Jeremy sufficiently answered that probably 4 times for us, so thank you.
I don't mind. There was a lot of hype around the case. Everybody thought it was going to kind of solve all these questions, and then they were very explicit. No, we're not solving all these questions. We're solving this question. So,
That's all I have tonight, sir. Thank you.
Okay, public commentary. Do we have any, Brian?
Yvonne?
Yvonne? No? Okay. Board member commentary. Stacy, start. Gary?
I'm good.
Mary? Darla? Gary? Brian?
I'm good.
And I'm good. Okay, can I get a motion to adjourn?
Motion to adjourn?
Do I have
Support.
support? Show of hands? Okay, the Monroe Public School Special Board Meeting for Monday, July 20th, 2026 is adjourned. The time is 8:51 PM.
Meeting next Monday.
You were right.
everybody.